My name is David Simpson and I'm a barrister here in 3 Verulam buildings in London. In this video I'm going to talk about the conflicts of laws issues that have arisen in the last few years in the English case law considering derivatives documented under the ISDA Master Agreement. And specifically I'm going to be looking at questions of jurisdiction, applicable law and capacity. I'm particularly going to be referring to the Italian swaps litigation, under which a succession of Italian municipalities attempted to extract themselves from English law interest rate swaps. Much of that case law was prompted by a decision of the Italian Supreme Court in 2020 called Cattolica. That decision held first that as a matter of Italian law, public authorities do not have capacity to enter into derivative transactions that do not make certain disclosures about the mark-to-market value of the transaction and which constitute speculation rather than hedging. The second that held that derivative transactions that either provided for an upfront payment or extinguished existing loans constituted indebtedness and violated, amongst other things, Article 119 of the Italian Constitution. Now, Cattolica was regarded as a surprising decision, not least because it decided that legislation taking effect in January 2009 had in fact merely stated the law as it had applied in Italy since 2001. But whatever the rights and wrongs of the decision, it has meant that a large number of Italian municipalities which found themselves on the wrong side of interest rate swaps have sought either to have their disputes heard in Italy or to invoke in the English courts what they regarded as favourable provisions of Italian law. Turning first to the question of jurisdiction, you might have thought that one driver of litigation, or at least uncertainty, in this area was Brexit, but in fact ISDA responded quickly to the challenges posed by the UK's departure from, well, not just the EU, but also from the Brussels and Lugano conventions. In 2018, it issued new model exclusive and non-exclusive jurisdiction clauses, which dropped references to convention courts and instead sought to take advantage of the machinery for exclusive choice of court agreements in the Hague Convention. To date, these clauses seem to have held up well. However, parties are of course at liberty to amend the model terms of the Master Agreement as they see fit, and bespoke jurisdiction clauses are not at all uncommon. However, tinkering with standard wording can obviously give rise to additional legal risk, and this is particularly an issue with the Master Agreement because the court may have regard to the words deleted from the standard wording if to do so assists in resolving ambiguity. So, for example, in Dexia and Trentino, the parties combined paragraph 1 of the exclusive jurisdiction clause with their own variation on clause 3 of the non-exclusive jurisdiction clause. Trentino argued that this clause permitted it to take substantive proceedings in Italy. Mr. Justice Bryan disagreed and concluded after extensive argument that the clause was an exclusive jurisdiction clause which also permitted provisional and protective measures in the Italian courts once proceedings had been brought before the English courts. A number of cases have concerned the interrelation between the jurisdiction clause used in the Master Agreement and competing jurisdiction clauses in more or less closely associated documents. These have included a mandate agreement under which the bank had agreed to evaluate and organise the management of the swap counterparty's debt and liquidity, a convention by which the bank had agreed to provide advisory services to the swap counterparty, a financing agreement hedged by the swap itself, and a settlement agreement relating to the swap. All of these attempts failed, but there have been so many attempts that they have given rise to a small body of case law dealing with situations where multiple contracts between the same parties contain competing jurisdiction clauses. Lord Justice Hamblin summarised the relevant principles in BNP Paribas and Trattamento, emphasising the need to take a purposive and commercial approach and recognising that competing clauses in a suite of agreements are unlikely to be intended to overlap. In Trentino, the municipality also tried to circumvent the effect of a jurisdiction clause by arguing that since it lacked the capacity to enter into an interest rate swap documented under a confirmation, it also lacked capacity to enter into the master agreement to which the confirmation cross-referred. Alternatively, it argued that the master agreement and the confirmation should be regarded as a single suite of documentation which should together be treated as void. Mr. Justice Bryan rejected those arguments on the basis that entry into the master agreement under which the claim was brought long preceded the confirmation, and that any lack of capacity to enter into a particular derivative transaction cannot and does not equate to a lack of capacity to enter into an ISDA Master Agreement. However, he did acknowledge the possibility that a confirmation entered into at the same time as a Master Agreement might be regarded as a single transaction, so that argument might have had better prospects of succeeding in different circumstances. Finally, a contention that England was not the forum conveniens for the adjudication of an Italian swap claim was swiftly dispatched by Mr. Justice Butcher in Dexia and Brescia on the grounds that the waiver clause found in both the exclusive and non-exclusive jurisdiction clauses amounted to an irrevocable waiver of any such argument. Where jurisdiction arguments have not helped, swap counterparties have often attempted to get the benefit of favourable provisions of their home state legal system by arguing that those provisions form part of the applicable law of the contract. Such attempts have to date uniformly failed, and challenges to arrangements documented under the Master Agreement are now likely to be dismissed by way of summary judgment following the decision of the Court of Appeal in Banco Santander Tota. Santander was actually the first case to be heard in the financial list. The case concerned snowball swaps entered into by Portuguese public sector transport companies with the Portuguese subsidiary of the Spanish bank Santander. The transport companies swapped a fixed interest rate for a floating rate pegged to Euribor or LIBOR. The snowball element meant that the fixed rate paid by the transport companies was subject to an additional cumulative spread at each payment date once the reference interest rates had moved outside upper or lower barriers. The collapse in those reference rates in 2008 led to the cumulative interest rate payable on the swaps ranging from around 30% to over 92%, and the mark-to-market value of the positions fell to minus 1.3 billion euros. The transport companies ceased to make payment under the swaps, and the bank sought a declaration that they remained legal, valid and binding obligations. The swaps were documented under the Master Agreement, and English law was identified as the governing law. Notwithstanding this, the transport companies argued, amongst other things, that pursuant to Article 3 of the Rome Convention, certain mandatory rules of Portuguese law applied, under which, first, the swaps were void as unlawful games of chance, and second, the swaps were liable to be terminated under Article 437 of the Portuguese Civil Code due to the abnormal change of circumstances since they were entered into. Under Article 3.3, the choice of a foreign law by the parties does not prejudice the application of mandatory rules of a country which cannot be derogated from by contract, but only if all the other elements relevant to the situation at the time of the choice are connected with that country and that country only. In a decision of some importance for the international swaps market, Mr. Justice Blair at first instance accepted the argument of Santander that relevant elements for the purposes of Article 3.3 are not confined to matters going to conflicts of laws only, so elements specifically pointing to a different country, but also include matters which point to the situation having an international character rather than a purely domestic one. In the present situation, relevant elements included the right of Santander to assign the swaps to a bank outside Portugal, namely its Spanish parent company, the use of standard international documentation, namely the multi-currency cross-border form of the 1992 ISDA Master Agreement, the practical necessity for the relationship to be one with a bank outside Portugal, the international nature of the swaps market in which the contracts were concluded, and the fact that back-to-back contracts had been concluded by Santander with its Spanish parent in circumstances in which such hedging arrangements are routine. Upholding this judgment, the Court of Appeal accepted Santander's argument that Article 3 of the Rome Convention could only be engaged in a situation which is purely domestic and did not give rise to any international elements. This meant that the court had to perform an evaluative exercise in identifying relevant elements and assessing whether they were all connected with only one country. The Court of Appeal would only interfere with the results of that exercise where they were plainly wrong, and there were no grounds for doing so in the present case. Despite the inherently factual nature of the evaluative exercise required under Article 3.3, subsequent decisions considering transactions documented under the Master Agreement have effectively treated the matter as closed. Indeed, an attempt by a different Italian municipality to open up the issue of applicable law in Dexia and Provincia Pescara was disposed of by way of summary judgment by Paul Eggers KC, sitting as a deputy, who held that there was no scope for allowing any mandatory rules of Italian law to displace the express choice of English law made by the parties in the Master Agreement. That brings me to the issue of capacity. Even where arguments on jurisdiction and applicable law have failed, issues of foreign law pervade the question of capacity, because the capacity of a counterparty to enter into a transaction is governed by the law of the country where the counterparty is situated. In the case of a local authority, this is because it only exists by virtue of and within the confines imposed by the municipal legal system which brought it into being. Now, in the UK, the Localism Act of 2011 put an end to this kind of argument for local authorities. However, capacity arguments have been brought by a large number of foreign local authorities contracting under English law master agreements, very often with foreign banks. In Haugesund, a Norwegian commune argued that a swap it had entered into with an Irish bank fell outside its power under Section 50 of the Norwegian Local Government Act. In Vestia, a Dutch housing company argued that it lacked capacity under Section 2.7 of the Dutch Civil Code to enter into swaps with a Swiss bank. And in the Italian swaps cases, the municipalities have argued that swaps they entered into with German, Irish, French, American, and indeed Italian banks fell foul of Article 119 of the Italian Constitution and various laws passed under it, as interpreted in Cattolica. Some of the logical consequences of inserting foreign law capacity arguments into English law contractual disputes have been rather surprising. In some cases, a swap counterparty has asserted a lack of capacity under foreign law, even where that foreign law, if it applied to the contract itself, would treat the swap as enforceable by persons dealing with the authority in good faith. This was the situation under Norwegian law in Haugesund, where Lord Justice Etherton noted with some concern that the swaps contracts would be bound to be treated as void in the English courts under a contract governed by English law, even though English domestic law would treat them as valid and enforceable, and even though Norwegian private law would also treat them as valid and enforceable. Where an issue of capacity is raised, three interrelated questions tend to arise under foreign law. First, there is the question of how the relevant provision of foreign law should be characterised. Now, there's an important distinction between a counterparty having the power to enter into the swap contracts but being prohibited from doing so, as opposed to not having the power to do so at all. That is a question as to whether or not a provision of foreign law goes to the capacity of a corporation to exercise a right, or instead grants it such capacity but prohibits it from exercising it. So how does the court decide this? Well, that is a question of English law and involves asking whether there is a legal ability or substantive power to enter into a contract of a particular type, to be judged by reference to any constitutional documents, statutes, and rules of the law of the country where the corporation is situated. whether or not the foreign law in question applies a different test to the same question is beside the point. Second, in most cases on capacity, the key factual issue under the foreign law has been whether the swaps in question involve permissible hedging or impermissible speculation. The question as to the meaning of speculation in these cases is a matter of foreign law. Indeed, in Busto, Mrs. Justice Cockrell held that it would be positively inappropriate to superimpose English law concepts of hedging derived from cases such as UBS and KW Leipzig and Standard Chartered and Ceylon Petroleum onto what ought to be a question under foreign law. However, in reality, trying to draw a distinction between how different legal systems approach these concepts seems pretty difficult. Finally, even if a counterparty possesses capacity, questions may yet arise as to the actual authority of agents acting on its behalf, which is a question of the law applicable to the relationship between principal and agent, or alternatively as to the agent's apparent authority, which is a question of English law. And where a lack of authority is found, then there are likely to be questions of ostensible authority and ratification, which are matters of English law. Stepping back, the vexed nature of all these questions has itself led to a great deal of judicial consideration as to how the English court ascertains and applies foreign law. This question has been particularly acute because of the controversial nature of the decision in Cattolica. Faced with that decision in Busto, Mrs. Justice Cockrell considered that the court was entitled to diverge from even the highest authority, particularly in the context of a civilian legal system. By contrast, Mr. Justice Foxton in Venezia took foreign law to mean the law with whatever imperfections, policy-orientated determinations and impracticalities it manifests, only for the Court of Appeal to reverse his decision on the meaning of Italian law. In his decision, Mr. Justice Foxton observed with perhaps a little exasperation that there may be room for a legitimate debate as to whether, when the issue arises before an English court, the security of obligations governed by English law should be capable of being subject to a continuing jurisprudential jeopardy of this kind arising from the courts of the domicile of one of the contracting parties. Now, I'm not sure this video is the place for that debate, but I hope it has illustrated some of the complexities that can arise from the conflict of laws issues involved in swaps contracts documented under the ISDA Master Agreement. If you would like to discuss any of the issues that I've talked about today, please do email me on dsimpson@3vb.com.